Good afternoon, students. In the current session of environmental law, we are going to revise the concepts from Unit 2, like constitutional provisions concerning environmental protection, provisions concerning environmental pollution under Indian Penal Code and Criminal Procedure Code. So now we'll see that when we talk about Constitution of India, we know that it did not, contain any specific provision for the protection and promotion of environment for that matter. And it was in 1976 the Constitutional 42nd Amendment Act was passed, and it expressly, incorporated specific provisions related to environmental protection, and it also improved in the form of added fundamental duties and directive principles of state policy that along with the 42nd amendment of the constitution. When it was being adopted, it was in response to the the provision which was being adopted related to environment. It was a response to Stockholm Declaration that was adopted by UN Conference on Human Environment in 1972. Now we know that how important this Stockholm Declaration, how important role does it play when we have to understand the relationship between the man and its relationship with the environment, and how well this declaration has played a role in molding and in shaping our environmental policies. And this because the declaration, it emphasizes that it is the man who bears the sole responsibility to protect and improve the environment for present as well as the future generations. So after 1976 amendment, the directive principles of state policy and the fundamental duties chapter of the Constitution of India, it initiates the national commitment towards the protection and improvement of environment. So we have seen that also when we talk about the constitutional provisions, we have seen the preamble, how the socialist characters talks about the resources and the role of the state. And then we have discussed about the legislative machinery, the distribution of legislative power, which is part 11. And we have discussed in an extensive manner article 250, 246, 248, 49, 250, 253 and 254. So when we talk about the legislative relationship between the union and the states, which is governed by part 11 of the constitution, article 246 of the constitution makes a division of legislative powers, the areas between union and the states, with the reference to the three lists that we have discussed, the items which are particularly concerns the environment in union list, state list and congruent list, that we have discussed in the proper details in our classes. So these list, which is given in the 7th schedule of the constitution. Then article 246, which provides that the parliament has the executive power to make laws for the whole or any part of India with respect to matters enumerated in list 1. And then we have discussed about the furthermore, when we talk about article 254, we have it talks about parliamentary legislation on matters provided in the congruent list, a predominant vis-a-vis state legislation. And it clarifies that under article 3 254, that in cases of conflict between parliamentary and state legislation on the matters in the congruent list, that parliamentary legislation shall prevail, or will prevail over the state legislation. And then when we look at Article 249 and 250, it empowers the parliament to make laws on matters containing in the state list, and if the question of national interests requires, and if a proclamation of emergency is in operation. And when we further talk about article 252, if we have seen that if two or more states legislature consent to central legislation on a matter contained in the state list, then it shall be a law for the parliament to legislate on the matter which otherwise forms parts of the state list. So on the when on the consent when given by the state legislation, two or more, they can request the central legislation also to make a to legislate over matters which is given under state list. Now when we have article 253, which enables parliament to make laws for implementation of international treaties, convention, decisions taken at the international conferences, like we have seen that accordingly the Water Prevention and Control of Pollution Act was enacted in 1974 to implement the decisions taken at Stockholm. And Likewise, we have seen Air Prevention, Control and Pollution Act 1981 and Environmental Protection Act of 1986 were passed by the Parliament under, Article 253 of the Indian Constitution. Then we have discussed about the fundamental rights. What are the articles which are directly, related with the constitution, with the environmental protection, under which we have discussed, will be revising them now. And then articles of the provisions, constitutional provisions, which is given under directive principles of state policy, and how article 48A was added, and fundamental duties, the responsibilities. So when it comes to environment, it's not just the right to enjoy free free from pollution, environment which is free from pollution, right to have a wholesome environment. So all of this also comes with a duty to protect the environment. So all of it we have discussed in our classes. Now we shall look into the constitutional provisions which is given under the fundamental rights. Okay, so now we are going to revise the most important part of this unit. That is the constitutional provisions which is given under fundamental rights, which ensures right to environment. So now we know that the how important role judiciary plays in this, in shaping up this whole protection that has been given pertaining to environment. So now here we know that right to environment is not expressively, provided in Part 3 of the Constitution, and it was but through the series of judicial decisions that judiciary has taken into account under Article 21 that it is implicitly now is present, very much present. And by this court have maintained the principle one of the the Stockholm conference, the Stockholm declaration, which says that the man has fundamental right to life in an environment of equality. So here we have discussed many provisions under which you article 21, article 14, 19, 19 like 191G have been used for environmental protection, in a very proactive manner by the judiciary. And we have seen that how Supreme Court has, with the help of different case laws, we have seen how Supreme Court of India has strengthened Article 21 by ensuring us, and has interpreted it in a manner that it ensures that right to wholesome environment along with right to livelihood. So Supreme Court has recognize several unarticulated liberties that are implied by Article 21. And it also interprets the right to life and personal liberty to include right to environment too. So we have seen that if we have to see Menaka Gandhi versus Union of India case, how it required law affecting personal liberty to also pass the test of Article 14 and 19 of the Constitution, and thereby it ensures the procedure depriving a person of his life or personal liberty be reasonable, fair, and just. And it does not, because life doesn't mean just mere existence like animals. Existence of life with dignity is important. And then we have seen with the help of the Supreme Court and High Court cases that that reads that the right to wholesome environment is a is a part of right to life, and hence guaranteed under Article 21 of the Constitution of India. And we have seen through cases like we have rural litigation entitlement kendra. So here you also need to trace, because I have been teaching you that how Supreme Court played 80s onwards, it plays a very crucial role in shaping up this whole environmental jurisprudence. And we understand that the Supreme Court entertained the writs under Article 32, but specifically provided as which right is violated. So writs are used on violation of fundamental rights, we know that. And it did not make any reference to basic article, that is 48A, but first indication of recognizing the right to live in healthy environment as part of Article 21 was, we have discussed, it was first time evident through the case of rural litigation entitlement kendra, Dehradun versus state of UP, the case of 1985, which is also famously known as Dehradun Missouri Hill Clearing case. And when we talk about rural litigation case, we know that it was the case where the Supreme Court of India has implemented right to wholesome environment as a part of life. life enshrined in Article 21 of the Constitution. And when we talk about the Supreme Court's under this case issued directions also for the government, that what all activities should be, how the activities are to be catered so the environment can be protected. And in the court was not only concerned with the lives, welfare of the mine operators, but also workers which were left unemployed. And then when we talk about the scope of the expansive scope of article 32, which the court from here, apart from issuing direction under article 32, forged new remedies and new ways or new strategies to design, have been designed by the Supreme Court of India to enforce fundamental rights. And the power under article 32, as we know, is not just confined to preventive measures with when fundamental rights are threatened or violated, but also it extends to remedial measures when the rights are already violated. And now what can be done, so what kind of reliefs that can be granted. So we have seen through Bandwa Mukti Morcha versus Union of India case, that where the court has held the power to grant remedial relief in appropriate cases where the violation of fundamental right is gross and patent and affects person on large scale. Affected person are poor and backward, then how the treatment has to be done. And then how we have discussed through MC Mehta versus Union of India case, the very famous case, where this principle of absolute liability, or when we in which we have expanded this rule of Rail versus Fletcher rule of, how we have discussed strict liability and how absolute liability principle was evolved by Supreme Court of India. And then issue of compensation we have discussed, in cases where MC Mehta versus Union of India in 1998 cases, where the first the court discussed Article 48A, 51AG of the Constitution, along with the provisions of Water Act and Environmental Protection Act. And here the court focused on that that not just these articles, but also they have discussed the issue with regard to wholesomeness and cleanliness of the water. And in this, the main part of the judgments says that there is no reference to right to life and the need to protect the environment. But it was, when you see the judgment, it was evident that the fundamental right, it was evident that the judges have taken the view that whenever fundamental right is violated by alleged pollution, and this violation entails that the court has to interfere and issue directions for remedy, despite the mechanism whichsoever is available under specific acts. And then we have discussed about how high courts and, along with Supreme Court, how high courts have been playing a very vocal and active role. And we have discussed it through T Damodar Rao versus Special Officer Municipal Corporation Hyderabad case. And now we have seen, after that we have seen the approach of Supreme Court. We have discussed that how approach of the Supreme Court is being changing with, we have seen MC Mehta versus Union of India trust trapezium case, MC Mehta versus Kamal Nath, where public trust doctrine, then precautionary principle, such sustainable development principles were applied. And how, what is the role, or what is the stance of the Supreme Court, how Supreme Court approaches the issues of environment. So, and it like we have seen in the observation of the court, or the stance of Supreme Court is that every citizen has a fundamental right to enjoy the quality of life and living as it is given under Article 21 of the Constitution. And when anything which endangers or impairs by conduct of anybody, either in violation or derogation of laws, the quality of life and the living by people and the life of the people, the persons are people is, the person, that person whose right is violated will be entitled to take the recourse of Article 32 of the Indian Constitution. So when it comes to environmental matters, they are not just just dependent upon the specific acts which has been provided by the, through legislation, but they are very much protected through the through Article 32 also. So when we talk about Article 21, it talks about protection of environment along with right to livelihood of people. So we have discussed Olga Tellis versus Mumbai Municipal Corporation case, where we understand that we have understood the view that of the court, that the right to life does not mean mere real life, which can be taken away or extinguished, and or by imposition or execution of death sentence, except according to the procedure established by law. That is the one aspect of life. But it is also an important aspect of life when we talk about livelihood. So if the right to livelihood is not treated as right to part of life, then it would be another easiest way of depriving a person of his life to life only. Because if you deprived him of his livelihood at one, or or abrogate his right to livelihood to some limit, it will eventually affect his life only. And in a view of this fact, that article 39A and 41 require the state to secure an adequate means of livelihood and right to work, it would be a sheer a sheer failure to exclude the right to livelihood from the content of life itself. And then we have discussed that how all persons have the right to clean and livable environment throughout the territory of India. It's subject to any law imposing reasonable restriction also in the interest of general public. So when you talk about the right, you know that your rights are not absolute, they are open for restrictions, so open to restrictions also. So a question arises whether the right to clean environment under Article 21 is confined to human beings only, or it extends to animals, plants, and other components of nature. So now here the Supreme Court has observed that the environment being a compendium of many things, amalgamation of many things, the expression person in Article 21 may be interpreted as an entity, as an entity having legal personality. And this is not correct. Simply because the Himalaya or a particular river defines a definition of a legal personality, the law has nothing to offer. So who will claim compensation on behalf of such non-jurisdict entities or victimized by the activities of industry? Thus what we understand is that the right to clean environment under Article 21 is not just confined to human beings, but it is also it extends to other animate inanimate objects of the environment also. Now, apart from right to life, when we have also discussed, cases where like Church of God Full Gospel in India, KKR Majestic, a Colony Welfare Association, where the noise pollution amounts was held as a violation of. Was held to be violative of Article 21, and which was related to noise pollution. So now Murli S. Deora versus the Union of India case, where the health of the non smokers were being given consideration, and it was being held that the smoking is injurious to health and may affect the environment or the health of the non-smokers also, and how it was being banned in public places. And further we have when we have dealt with fundamental rights to equality, we have seen that how Article 14 of the Constitution enshrines the right to equality before the law, protects a person against arbitrary unreasonable state action, and how we saw it with the help of Kinkri Devi versus state of Himachal Pradesh case. And further, we have discussed about the fundamental rights, right to profession and trade and business. And with the cases that we have discussed in classes, we saw that the how Constitution, principle of constitutional right 19, which is given under Article 19(1)(g), it is been balanced out. So how the Supreme Court, how the courts have been balancing environmental protection along with our right to livelihood, our rights, and so economic activities, how the court has been is been developing this equilibrium, balancing out the interest of the financial interest in terms of economic activities and the need of environmental protection also. And we have seen then after that we have discussed about the whole rights which is by enshrined under directive principles of state policy, which are directives for the government to follow and are non-enforceable. So we have discussed about the rights and duties in the form of DPSP rights, which is, provisions which are concerning to environmental protection, and provisions which is given under fundamental duties chapter. So 42nd Amendment Act, we know that Amendment Act of the Constitution of 1976 has introduced Article 48A and 51G AG in the Constitution. So fundamental duties were added in the Constitution, out of which, so now here we know that the fundamental duties are social obligations, and we know that Article 51 AG, when we talk of the Constitution, it imposes a duty on every citizen to protect, improve a natural environment, and that includes forests, lakes, rivers, wildlife, and have compassion towards, for living creatures. So preservation and conservation of environment, striking this, keeping our ecological balance is now a task for every one of us. So which is not only for the government but also for the citizen to undertake too. And this is now not just a social obligation that all of us has to follow with the provisions, with the specific acts. Now it's a duty also for us, that is being bestowed upon us. So Article 48A, if we talk about, and 51 AG, the relationship between the two, they both acts like a constitutional pointer for us to the for the state, and for the constitutional duty for the citizens, not only to protect but also to improve the environment, to preserve and safeguard the forest, the flora and fauna, rivers, lakes, the resources that we see. And when in situations where they are neglected, and when they are failure to abide by these pointers or to perform our duty, it will be considered as nothing short of but betrayal of the fundamental law, of which the state and every Indian has to follow, and is bound to uphold and maintain. So that is a duty of the every state, duty of a state, not just the state but also the individual, to protect and improve environment. We have seen it through various case laws that we have discussed in our classes, like Virender Gaur versus State of Haryana, where the Article 48A has been observed by the Supreme Court, enjoins the duty on the state, duty that the state shall endeavor to have to protect. So what shall shows that it's mandatory, obligatory for the state to do that. Now endeavor to protect and improve the environment, to safeguard the wildlife and of the country. And 47 further imposes a duty on the state. Article 47 says that the state to improve the public health, as it will be a primary duty. And 51A imposes a duty on every citizen of India, 51AG, to improve, protect the natural resources, the environment. And so here, if you understand the perspective of the court, the Supreme Court, it gave effect to social obligation to protect the environment, and reminded all of us, all the Indian citizen, of their fundamental duty, which is enshrined under Article 51 AG, with this Rural Litigation Entitlement Kendra versus State of UP. And it has showed us that how the human actions have consequences when we interfere with the nature, when we interfere with ecology and environment, how we not just interact, on how not we just interact, but also we have impact, which is not necessarily all the time good. So we have to be careful of our action, we have to fulfill our duties, because it is now not just obligation, it's not just obligation for the state to maintain, but also for the citizens, and they have to every time be reminded of that they not just have the rights to enjoy, but also the duty to fulfill, in order to protect and conserve the environment, to keep on the balance, the ecological balance, so that we have to act in a way that the environment stays preserved, and we maintain its sustenance, and the ecological balance is unaffected by our actions. So it's not just a task for the government, but it's also a task for every citizen that we all must undertake. Now, when we talk about the provisions concerning environmental pollutions, we have discussed from the provisions of Indian Penal Code and the Code of Criminal Procedure 1973. We have discussed Chapter 10 from CRPC, and we have discussed about sections, which is given under these this chapter. So which talks about like sections where, 131, power of certain armed forces officers to disperse assembly, 132, protection against prosecution for acts done under preceding sections, and a very important section 133, section 133, which is related to public nuisance, which talks about order, conditional order for removal of nuisance. And then the following provisions we have discussed in the class, where we have discussed urgent cases of nuisance or apprehended danger, when section 144, which talks about power to issue order in urgent cases of nuisance or apprehended danger. Now 145, which talks about procedure where dispute concerning land or water is likely to cause breach of peace. And then we talk about IPC chapter 14 we have discussed, and in which chapter 14 is particularly about offences affecting the public health, safety, convenience, decency, and morals. So in which we have looked into section 268, which talks about public nuisance, 269, a very important section which says that negligent act are likely to spread infection or disease. So it says that it shall be, the person shall be, if the act is likely to spread the infection or any disease which is dangerous to life, shall be punishable with imprisonment of either description for a term which may extend to 6 months or fine, or with both. Then we have done with the section 270, like which deals with malignant act likely to spread infection and disease dangerous to life. Now in the persistent situation, all these sections becomes all the more important for us. No Section 271, which you can now interrelate well, that is disobedience to quarantine rule, and 272, adulteration of food and drinks, that it talks about. And then we have talked about uh, you know Article 278, 277. 278 is about making atmosphere noxious to health, or 277, which talks about fouling water of public spring or reservoir, which says that whoever voluntarily corrupts or fouls water of any public spring or reservoir, tenders it less fit for the purpose of its ordinary use, shall be imprisoned, shall be punished with imprisonment of either description for a term which may extend to 3 months, or fine, or may extend to 500 rupees, or with both. And provision which deals with making atmosphere noxious to health, it talks about 278, it talks about whoever voluntarily vitiates the atmosphere and make it noxious to health of persons, shall be punishable with fine which may extend to 500 rupees and more. And then we have discussed sections like uh, 284, which deals with negligent conduct with respect to poisonous substance. And the all the preceding sections we have all the preceding and subsequent sections we have discussed, which deals with the, which is given under chapter 14, and which is related to the pollution, the offense which can uh, which can lead to problems to public health and safety, and the offenses affecting public health and safety, and the prescribed punishment. We have discussed all these provisions in the classes. So, and we have discussed it with the help of case laws. So now, whenever you're dealing with these concepts, you have to write about the case laws that have been discussed in classes, and then you also talk about the other general provisions which is given under like constitution, and other specific provisions which is given under the specific acts like environmental protection, water act, and other acts that we have done in our sessions.